Welcome to Real Quick Media. I'm Dr. Q. Today, the trial officially begins, and last week, the court released a long list of filings that outline what this entire case is really going to look like in federal court. These filings cover everything: who qualifies as media, which statements are automatically considered harmful, how old content can be used, what exhibits the jury will see, and even how the First Amendment does and doesn't apply here. And to make sense of it all, I'm starting with the first major filing, the one that sets the foundation for every other issue in this case. Just days after my documentary breaking down Megan v. Milagro dropped, the court filed several updates addressing the exact issues I covered: online gossip, journalistic privilege, and whether Milagro can legally call herself a journalist. The judge didn't rely on arguments. She went straight to Milagro's own live streams to make that determination. Not her thumbnails, not her tone, not even how her audience sees her, just what she said on camera. From her own broadcast, she said, "Everything is not meant to be a news report. I did not tell anybody I was a reporter. And again, I ain't never told you I went to school for journalism. I shouldn't be regarded as a news source any way." The judge cites this directly. Defendant has publicly admitted she is not a journalist. And she draws the boundary clearly. Nothing about this alleged conduct suggests an effort to impartially disseminate information. Because of this, the court denied Milagro's First Amendment arguments that only apply to journalists because she didn't qualify. This wipes out every argument about press protections or reporters' privilege. The statements she made publicly, on camera, now define how the court categorizes her speech. And this is exactly what I warned about in episode 1. The same protections that safeguarded activists and journalists in the 1960s can be misused by bad actors today, hiding behind the banner of free speech. And now, a federal judge is echoing the same warning, drawing a line between journalism and commentary, the very line that I said would shape the future of free speech for creators. And that standard may not only apply to Milagro. Once a federal judge defines who counts as press, the same standard could plausibly apply to anyone invoking journalistic privilege. And this is where Akademiks becomes relevant again. He's not a defendant in this case, but he did invoke journalistic privilege in his own deposition after tweeting about sealed DNA information during the Tory Lanez trial, which I covered in my documentary. Journalistic privilege is not about platform size, it's not about influence, and it's not about how someone presents themselves online. It's about whether the conduct meets the legal standard of journalism. And if it doesn't, the privilege does not apply. And courts can compel answers. So that's the first major update. The court isn't treating this as journalism, and Milagro's own live streams made that clear. The same standard could apply to anyone calling themselves press without doing the work. And when the court decides who you are legally, the next question is simple: what exactly did you say? Because the next set of filings move straight into the statements that law considers automatically harmful. That's the next update, so stay tuned. Be sure to like, comment, and share, and subscribe so you don't miss the gems I drop in the next video.